From the PEP Radio Newsroom, this is the Hourly News Blast. Advocate is reporting the U.S. Supreme Court on Tuesday upheld state bans on transgender girls and women competing in girls and women's school sports, delivering a major victory to Republican-led states and a devastating defeat to trans students who had asked the justices to let them participate in public school life as themselves. In a 6-3 decision written by Justice Brett Kavanaugh, the court ruled that Idaho and West Virginia's laws do not violate the Equal Protection Clause or Title IX. The Title IX part was a unanimous decision, but we digress. The cases Little v. Hecox and West Virginia v. B.P.J. centered on two transgender students, Lindsay Hecox, who sought to run track and cross country at Boise State University, and Becky Pepper-Jackson, a West Virginia girl who wanted to compete on girls' teams at school. For years, conservative lawmakers have positioned transgender girls' participation in sports as an emergency, even as the number of students affected remains small. The legal campaign was never only about who gets to run a race or join a team. It was about whether transgender people can be carved out of public life by category. The majority rejected arguments that the laws discriminate against transgender students, relying on the court's recent decision in United States v. Scrimeti to say the bans classify students by sex, not by gender identity or transgender status. Writing for the majority, Kavanaugh said the court would not require states or schools to make athlete-by-athlete determinations about whether a transgender girl who has taken puberty blockers or hormones has retained any athletic advantage. Of course, Kavanaugh wouldn't know a damn thing about science if it smacked him upside the head. Particularly in the sports context, determining the effects of the puberty blockers and hormones taken by transgender athletes and then comparing each of those transgender athletes' abilities to those of other individual biological males and individual biological females in the relevant sport would be an almost impossible task for a judge to perform on an equitable basis, Kavanaugh wrote. Well, that's probably because judges know a whole lot about law, but not a damn thing about science. Duh. Kavanaugh said Title IX allows schools to maintain separate girls and boys sports teams based on what the court called biological sex, and that states may use the same rule under the Constitution, because the Constitution was written in the 1780s when women couldn't even vote, so keep that in mind. Schools may determine eligibility for women's and girls' sports based on biological sex, he wrote. Kavanaugh was joined in his idiotic opinion by Chief Justice John Roberts and Justices Uncle Ruckus, Samuel Alito, Neil Gorsuch, and Amy Coney Barrett. Thomas and Gorsuch, a.k.a. Justice Ruckus and Gorsuch, each wrote concurring opinions. Men and boys with gender dysphoria are not women or girls, even if they believe that they are, Justice Uncle Ruckus wrote. In a blistering partial dissent, joined by Justices Elena Kagan and Ketanji Brown Jackson, Justice Sonia Sotomayor warned that the court had cut off the students' constitutional claims before lower courts even got the chance to resolve key factual questions. Sotomayor agreed that Pepper-Jackson's Title IX claim failed. That goes back to the whole 9-0 on Title IX, but said the majority went much further than it needed to. The central fight in her dissent was over equal protection, the 14th Amendment. She wrote that West Virginia used a sex-based classification and therefore had to satisfy heightened scrutiny. Pepper-Jackson, she said, should have had the chance to prove that the state's stated interests in safety and fairness did not apply to transgender girls like her who had not experienced endogenous male puberty and who receive gender-affirming treatment. Today, the court holds that neither Title IX nor the Equal Protection Clause are worth their weight in stone. Protects B.P.J's ability to do so, Sotomayor wrote. She accused the majority of applying a form of heightened scrutiny divorced from this court's cases, frankly, from reality, and said it had denied Pepper-Jackson the chance to test West Virginia's claims in court. Yet in an opinion unencumbered by fact or law, The majority today cuts off that process prematurely, deciding that B.P.J's case must end now, Sotomayor wrote. We'll have part 2 of the story during the evening news blast. PEP Radio is available on the Live 365 app, the PEP Radio page at paequality.com, Roku, Alexa, and you know what? Wherever you find streaming radio. Up next, we have the Meadville area weather forecast here on PEP Radio.